Hello, and welcome back to Doing Business As, the small business law podcast from Tracktown Law. I'm your host and founder, Jared Height. At Tracktown Law, we help individuals and business owners in Oregon and Idaho navigate estate and business planning with clarity and confidence. And today, we're talking about one of the most overlooked but essential legal documents in your business, the operating agreement. Especially if you've formed a limited liability company, or you plan to, this is something you can't afford to ignore. It's not glamorous or exciting, but if your LLC doesn't have a solid, customized operating agreement, it's not protected. And if you grabbed a free template from the internet and filled in a few blanks thinking that would cut it, I promise it won't, not when it matters. We're going to look at exactly why these generic agreements fall short, especially under Oregon and Idaho law. We'll talk through real risks, real outcomes, and real ways to avoid them, and I'll walk you through some examples. A quick disclaimer before we dive in. I am a licensed attorney in Oregon and Idaho, but listening to this podcast does not make me your lawyer. Nothing here is legal advice for your specific situation, but it should help you ask better questions and spot issues before they become expensive problems. So let's get into it. If you own an LLC, or are thinking about forming one, here's the conversation you need to have. First, what is an operating agreement? An operating agreement is the internal contract that governs your LLC. It spells out who owns what, who does what, how decisions are made, how profits are shared, and what happens if someone wants to leave, dies, or stops pulling their weight. Without one, you're stuck with the state's default rules, and those rules were designed for simplicity, not strategy. Both Oregon and Idaho have adopted the Uniform Limited Liability Company Act. This law says you're free to write your own rules, but if you don't, the state will impose theirs. So, what are those default rules? Well, in both Oregon and Idaho, unless you've got something in writing that says otherwise, profits and losses are shared equally. That means even if one member contributed 90% of the startup capital and does 90% of the work, they're still only entitled to half the profits, or a third, or whatever the headcount is. Not their workload or their risk, just one share per member. Same with voting rights. By default, every member gets an equal vote, even if ownership percentages are wildly different. If you own 70% of the company and someone else owns 30%, you still get one vote each. That creates a recipe for deadlock, resentment, and dysfunction unless you've spelled it out differently. Then there's the example of what happens when a member dies, leaves, or goes silent. Without a buy-sell provision or exit plan, state law might require your LLC to dissolve, even if you're profitable, even if the other members want to keep it going. That's not just inconvenient, it can mean selling assets, losing contracts, and burning years of work. Let's walk through a few examples of what this looks like in real life. Here's one out of Idaho. A pair of marketing professionals in Boise decide to launch a boutique digital agency together. One is a designer, the other handles sales and client management. The designer puts in $60,000 to fund the first year. The sales partner contributes services and a handful of client leads. They use a free template for their operating agreement, one they found on a national business website. The template doesn't include anything about contributions, profit splits, or voting rights, just vague language about equal ownership and management. 18 months in, the business is growing fast, but so are tensions. The designer is working 60-hour weeks and wants to reinvest profits to hire staff. The other partner, who's contributing much less day-to-day, wants to start taking large distributions. And since the agreement defaults to equal votes, they're deadlocked on this and all other major decisions. Worse, the agreement doesn't address what happens if a member wants out. When the sales partner decides to cash out, there's no valuation method, no funding strategy, no timeline, just an unstructured mess. The designer ends up dipping into personal savings to buy them out at a number they had to negotiate mid-crisis. The business survives, but barely, and it never fully recovers its growth trajectory. Or let's take a Portland-based e-commerce company. Two founders bring on a third partner as an investor. She puts in money, but agrees to stay out of operations. The boilerplate agreement they found online mirrors the state default rules, giving all members equal voting rights. Fast forward 6 months, and she's using that right to second-guess every hiring and marketing decision, halting progress, and burning bridges. The founders feel trapped, the investor feels entitled, and there's no mechanism in place to buy her out. Now imagine a Eugene food truck run by siblings. One of them dies unexpectedly. There's no operating agreement. Under Oregon law, their membership interest passes to their estate, which now includes a spouse and 3 adult children. The remaining sibling suddenly has 4 silent co-owners with voting rights, no clear way to value the interest, and no plan for a buyout. That's a probate case waiting to happen, and a business at risk of being torn apart by grief, confusion, and legal expense. So let's talk about what a real operating agreement should actually include if you want to avoid these outcomes. First, capital contributions. You need a clear record of what each member is bringing to the table, whether that's cash, property, labor, or IP. Oregon and Idaho both allow non-cash contributions, but if you don't define them, they're open to interpretation, which means they're open to litigation. Second, profit distributions. If you want them to track ownership, workload, or a hybrid of the two, you have to write that down. Otherwise, the default is equal shares, and that's rarely what people intend. Voting rights. Again, if you want votes weighted by ownership, or if you want certain decisions to require more than a simple majority, spell it out. Include provisions for tiebreakers, especially in a 50-50 ownership setup. Courts in both Oregon and Idaho have dissolved otherwise viable companies simply because owners were deadlocked and had no agreed process to resolve it. Buy-sell provisions are key. These lay out when and how a member can sell their interest, how it's valued, and who has the right to buy it, and how that buyout gets funded. Without this, disputes are inevitable. I've seen businesses crumble because the remaining members couldn't agree on a fair price or afford to pay it up front. Death and disability, same thing. Do you want your partner's spouse as your new business partner? If not, you need a plan that specifies what happens when a member dies and how their interest will be handled. Both states allow flexibility, but only if you've made your intentions clear in writing. You should also include how new members are added, how debts are handled, how often meetings are held, what information has to be shared, and whether members can work for or start competing businesses. And here's something a lot of people overlook: liability protection. If your LLC looks sloppy, no operating agreement, no minutes, commingled funds, a court might decide that it isn't really a separate entity. That's called piercing the veil, and it can expose your personal assets to business debts. Oregon and Idaho courts look at how seriously you treat your LLC when deciding whether to uphold that liability shield. Having a detailed, well-followed operating agreement helps show you're running a real business, not just calling yourself one. So no, this isn't just paperwork. It's the foundation of your legal protection, and it's the framework that keeps your business relationships healthy. At Tracktown Law, I help LLC owners create operating agreements that actually reflect how they want their business to run. Clean, readable, and customized, not boilerplate, not bloated, just the clarity you need so that your legal structure matches your actual business plan. Because when conflict hits, and it will, you don't want to be flipping through a generic document wondering whether it even applies. You want answers, you want structure, you want peace of mind. If you're forming a business, or if you already have one and you're starting to second guess the template you downloaded 3 years ago, now's the time to fix it. You can read more in the companion blog post for this episode, available at tracktownlaw.com. It covers everything we've talked about today, with examples and tips for what to look for in your own agreement. And in our next episode, we're diving into one of the most common questions I get: LLC versus S Corp. What's the difference, and should your business make the switch? We'll walk through the tax angles, the structural issues, and the most common misconceptions so that you can make that decision with confidence. Thanks for listening.